Hi, guys. Thank you again so much for joining us today. As I said earlier, this is our first webinar for 2018, and I'm really excited that I was able to bring someone with quite a bit of legal knowledge to share with you about how you can better improve your contracts and improve your business, just to ensure that your business has all the right steps in place and you do have all the right structures and foundation to work with your clients and do that well and hopefully be successful while you're doing it. So before I jump into the session, I'll just take a few minutes to introduce Ticora and share a little bit more about why I think you will be learning so much from her in this session. So attorney Ticora Davis, Esquire. She is an attorney, she's a legal advisor and a business strategist. She's also a professor, a speaker, and a podcaster who founded the Creators Law Firm. And the Creators Law Firm is a boutique intellectual property and business law firm that helps creative entrepreneurs and small business owners protect their smarts. And she helps clients to successfully navigate their trademark, copyright, and licensing matters. Now, with her culturally relevant approach, Ticora is committed to empowering creatives such as yourself with the tools and knowledge that you need to not only understand your intellectual property, but to monetize your creative works. Now, her clients include Hollywood celebrities, award-winning wedding professionals, artists, creative entrepreneurs, designers, business coaches, and TED and TEDx speakers. And because of her innovative work, she's also been featured on VH1, WBTV Charlotte, Wedding Wire World, Behind the Veil, and The Session magazine. Now, I'll turn things over to Ticora so she can better inform you and teach us everything that she knows today.
Awesome. Thank you so much for the stellar introduction. I am so excited to be here today and share just my gifts and my talents and my expertise with everyone. Please let me know if you cannot see me or you cannot hear me, or if I look weird, just pop in the chat and let me know, because I want this to be a wonderful experience and I don't want any audio or visual technical difficulties to get in the way of this presentation. What I'm going to do now is pull up the presentation, and I'm a very interactive in terms of presenter. I love interacting with people, so I want you guys to ask questions throughout. We don't have to wait until the end, and we can definitely do that. So I hope that I'll still be able to see those questions popping up. And please let me know, Jody, if you are able to see the presentation.
Yes, I can see it, and I'll keep on top of the chat for you.
Okay, lovely. And you know what? We can, it's weird, but I can't see the chat or anything like that. So if someone has a question, Jody, please let me know and I'll stop and I'll answer in the midst of it, okay?
Will do.
Okay, lovely. So this presentation is going to cover 5 contractual mistakes that event planners make. Before jumping into anything, as any good attorney would do, I have to give a disclaimer. So today we're going to engage in a lot of shenanigans. We're going to have a lot of fun. But on a more serious note, I have to let you know that this presentation is for informational and educational purposes only, and it should not be construed as legal advice. I'd love to be your attorney unless a client engagement letter is signed and a few Ben Franklins are exchanged. That means money. No attorney-client relationship between me, you, or those in attendance shall be formed. Any information here is provided, is not considered privileged or confidential. So if there's something that you have or a question you have and you're like, oh, I don't want the world to know, the chat feature is not the means to probably ask that question, because everybody can see your business. If you have specific legal questions, you should seek the advice of an attorney who's authorized to practice law in your local state or jurisdiction. I'm also an intellectual property attorney, which is what's cool about trademarks and copyrights, so I can represent anyone in any state. So that's just a fun fact for you all to know. So, as Jody shared, I'm an attorney for creative entrepreneurs and wedding professionals. I'm the founder and managing attorney at the Creators Law Firm. I recently celebrated my 1 year in business, so I'm so excited that I survived my first year. And I think that really, in terms of running a business, I sometimes feel a little green, even though I'm going to be an attorney for 3 years in March. But I've learned a lot along the way, and I just love working with creatives and wedding professionals. So why do I work with wedding professionals? This is me on my wedding day. Any opportunity I get to share my wedding photos, I take it. So sorry, guys, you have to see. So this is like our little first touch, and my cute husband, you can't see his, but he's really handsome. And so why do I work with wedding professionals? Well, I work with wedding professionals because although I had a beautiful wedding and have an awesome marriage, but leading up to the wedding, I experienced a lot of, I would say, turmoil on behalf of a bride dealing with various vendors. From the first wedding planner I hired, and I should have known better as a budding law student. She gave me pretty much an invoice, and that was our contract. There was no formal contract. So it didn't really talk about how can we get out of this agreement, termination, what her service, what my expectations of her would be. It was lacking in so many areas. So as a bride, I had certain expectations, and I believe as a wedding planner, she did too. And we just didn't meet eye to eye because that contract did not serve either of us well. And so because I didn't trust her, I had to ultimately fire her, and I lost money. Then I ended up hiring another wedding planner, and she did a phenomenal job. But I had also hired some other vendors that, along the way on my own, and I didn't have before getting my wedding planner, and it was very difficult to transition all of that. I would even say, oh gosh, a week before my wedding, the person who was supposed to be driving the limo, he called and canceled on us. He said, well, it's prom season, and I can't pretty much be at your beck and call for the 2 hours you've hired me. And I'm like, hey, I drafted this contract. Again, I wasn't an attorney then. Thought I was a baby attorney. And I'm in my third year of law school. So I'm like, okay, I know how to write a contract. I put that together. I presented to him. And guys, he didn't even honor the contract. And I had him say, hey, you need to be, we're paying you by the hour. You need to be there for 2 hours. We paid him in full. And he was saying, no, I'm only supposed to pick you guys up and drop you off. I'm not supposed to wait around. So a week before the wedding, I had to scramble and find someone else to transport my bridal party. So I realized that, but I also had some other phenomenal experiences with those other vendors. And so I knew that sometimes it's a matter of supporting wedding vendors in this industry so that they can serve clients better. And that could be, encouraging you all to have the right systems in place. And a part of a great system is to have a contract that really serves you well. And so today, this presentation is going to focus on those 5 contractual mistakes that event planners make. But guys, I couldn't stop at 5, so you're going to get some extras.
That's good.
So what are you going to learn today? We're gonna cover those rookie contractual mistakes that event planners make and wedding planners make, the essential contracts that you certainly should have, and finally, you're gonna have a Q&A with Legal Bae. I'm your Legal Bae. I have a little disclaimer down here. I'm happily married, although I'm your Legal Bae. I'm not entertaining suitors. You're supposed to laugh. I got a laugh track at the bottom of this. So if you guys are not laughing, you're not participating in the presentation, okay? I need you guys to participate. All right. So how many of you all agree with this? And you can type in the chat. Jody, you let me know if they're agreeing. If something goes wrong on the wedding day, the bride is going to look to you first. Is that true? Type yes if you agree.
And you can also use that raise your hand option in front of you.
Yeah, the bride is going to look to you guys first.
Yeah. We're getting a lot of absolutely true. Yes, so true.
Right. Like, it's going down. If something goes down, they're looking at you guys first. I remember on the day of my wedding, I sat at my sweetheart table, and directly across from me was my wedding cake. And it was facing everyone, and it looked perfect because everyone was in front of us. But in my peripheral vision, my cake was leaning back like this. I was like, called my wedding planner over and was like, why is my cake leaning? Like, my cake is leaning and rocking. What's going on? So, I mean, I didn't care to ask for the baker or the DJ. I was looking for the wedding planner because she was supposed to oversee everything. I'll tell you guys that story on another day. So, great contracts is the power of the pen. Good contracts protect you, they protect your clients, and they protect your team. Guys, a contract is a great tool that covers the scope of the agreement that you have with your engaged couple. They protect you as the wedding planner and really the facilitator of this entire event. And it also protects your staff. A well-drafted contract will serve not only you, it'll serve everyone who is connected with you, and it helps govern the relationship. It is a tool that you should use and be empowered to use. And I hope that you walk away from this presentation feeling that. Mistake number one that I see is that there's no contract at all. That's one of the biggest mistakes that event planners make. It's simply a handshake deal. This could happen with your play cousin. It could happen with your brothers, sisters. Well, your brother, sister is your sibling, your brothers, aunties, whoever, So, hey, I've known this family friend, or they love me. They love my work. We've been childhood friends. I'm going to do this for you. I'm going to gift my services to you. No need to even, have a contract. There's nothing wrong with doing such things for people. But even then, you must have a contract at play if you decide to do pro bono services or donate your services to someone in need, because you still want to make sure that their expectations are met within the contract. And if they need to hire someone to do something extra, that should be outlined as well. Perhaps you're only going to plan the ceremony and not the reception. Perhaps that you're going to do things the other way around. Perhaps you're only going to provide a certain amount of staff. They need to know those things, even if there is, you're doing something for free or very little money, so that people understand what they're getting. Mistake number two, the contract that you do have in place lacks a detailed scope of work. It doesn't fully explain who you're serving, what you're doing, the date, where, and how many people that you are serving. And not only does it not indicate how many guests, it does not allow for the flexibility if those guests go up. Because I know that your prices are going to be quoted based on the number of guests. But what happens if, everybody else from, her family flies in? And sometimes culturally those things happen. I know my friend, she's Nigerian, and she says she'll send out wedding invitations, and some people will not RSVP. Or extra family members will show up the day of, and culturally that's accepted. Perhaps not so much in our American culture, or with respect to a contract, that doesn't serve you well as the event planner, but you have to account for those things within the contract itself. And so you can even put a clause within the contract that says, in the event, more guests arrive, or there's more things that need to occur, then that will be an extra fee, or it'll be charged at whatever your hourly rate is. Mistake number three, as what happened with me, the invoice should not replace a well-drafted contract. If you do have a proposal that you send to a bride, it must be followed up with a service agreement or your wedding or event planner agreement. That needs to follow the initial proposal that you send to clients, because an invoice is really going to detail, perhaps you have a design fee and a planning fee. Perhaps you're also a florist, or you all are multi-talented individuals with various sets of skills, or you might even have a full service wedding place, right? And so you can do multiple things. When they hire you, they don't need to go to 20 different vendors. They could just come to you and you could facilitate everything else. So an invoice simply should serve as a means to outline in detail the items that the bride or the groom or the engaged couple, whoever it is, are hiring you to do, and they should be followed up by that service agreement. And again, if there's any questions as I go, feel free to ask. Mistake number four that I see, and I know you're like, really, an attorney is saying that? Your contract has too much legalese. If your contract is saying, hereto, therefore, thou, wherefore, all this legal language, that scares clients. Keep in mind, this is the first time clients are hiring a wedding or event planner. This might be their first time hiring someone to plan an event or for them or facilitate an event. And sometimes it might even be their first interaction with a contract of this nature. We don't want to have language that disempowers you as the planner because you don't even understand it and you can't explain it well. And it also creates fear within your client. That's why I think it's very important to either purchase a contract template from a well-respected creative attorney. You can get a lot of these contract templates offline. I wish I had my site up today because I'd certainly dropped the link, but my site will be up next month. But that's a great place for you to start. You can get a great contract from a creative attorney online, and you can have that and put it in place and allow that to work for you. And that language will really help, because most of the time those creative attorneys are saying the same thing that I'm saying. The contracts don't have a lot of legalese. And you want to be able to explain your contract. If you're not able to understand certain provisions, it doesn't help you explain it. The fifth mistake is that I see that event planners fail to prepare for last minute changes. Please type in the comments if there's ever been something on the day of the wedding or the day of the rehearsal where you or your team had to go out and run and get something on behalf of the bridal party. That could be Gatorade because somebody's about to pass out. It could be, oh my gosh, someone forgot, I got to run and get her a bra. I got to run and get deodorant. I have to run and get certain things. If you fail to prepare for those last minute changes or those last minute charges, then you're not able to bill that to the bride. A couple things that can be done. That can be built into the contract at the onset. In the event, we have to run and get something that the bride or engaged couple is going to compensate us. Or you can have, there's 2 apps that I recommend. One is called Shake, like a smoothie or shake. I think that's on Android alone, but it could be on iPhone as well. And the second one is Contract Maker Pro. These 2 apps allow you to create a contract on your phone and allow the engaged couple or whoever it is to sign it. And so literally, I think it's best to prepare that in advance. So you can have a contract that's literally, it has the date, it has a brief paragraph, on this day, this contract was between, your company and the bride. The effective date is this particular day. Bride is agreeing to compensate the wedding planner for these items that are purchased on this day on their behalf, and have them sign it, so that's something that you have on hand that protects you and your staff in the event someone has to go out and get food, because sometimes people forget to eat. I know I did. My maid of honor, she made sure I ate. I was so nervous on my wedding day. She was like, "You need to eat," and I'm like, "No, I'm fine." She was like, "No, eat these almonds, eat this hard-boiled egg." I was like, "Where's she getting all this stuff from?" Like, some people don't have the presence of mind to do something like that. Right. So you might have to step in and do that, but you also need to be compensated. And sometimes what someone may construe that as, if you don't have that contract or something prepared, oh, well, I thought that was just a part of what you do on the day of. You're supposed to make sure my day goes well. So why should I have to pay you for feeding me?
Latasha said she had to run and get the bride.
Oh, Lord. Wow. That is a story that you have to tell us, because, wow. Yeah, she's pretty important. Yeah. And so, it could even be a situation where, your mileage should be compensated, especially if she was really far away. So I think that you can always use your discretion. Perhaps you don't mind doing something. You don't have to charge for every little thing. However, if it's going to cut into your pay, cut into you being able to pay staff, if it's going to put a financial burden on you, I do think it's more than fair to make sure that you're compensated for the work that you do. Because you guys work really, really hard. You guys, if you're a business owner, you're the hardest working person in your business. You're going to work hard for no pay. You're going to work without sleep. You're going to work into the wee hours of the night, whether people see that or not. Trust me, I know as an entrepreneur. So we should be compensated for the hard work that we do. And it doesn't mean you're robbing anyone. It just means that you are getting paid. So I talked about those apps to modify contracts on the go. These are a few extra things that I also see, such as, you want to make sure that the contract, you might have a caveat in there. Let's say you're a designer and you say, "Oh my gosh, I would love to hang draping." We're going to agree to do that. But the venue says, "Hey, you're not able to hang draping or use open flames here," but that's what you said in your contract. You want to make sure that your design clause within the contract limits your ability to execute that styling based on the venue's parameters, because you can't violate that. You also want to ensure that your dining clauses, your feed me clauses serve you well. I always tell this joke and people think it's so funny. When I was younger, I said, Mom, I'm hungry. She said, well, make a sandwich. I was like, I want something hot. She said, heat it up. I don't know if you all have a mom like mine, but I just listen, when she said it to me, I was like, touche, Mom, I'm going to make this sandwich and I'm going to heat it up. So the reason why I say that is some people say, well, I want a hot meal. You know, a hot meal can be a lot of different things. You know, it could be a Subway sandwich. It could be some McDonald's or Burger King, because that's hot. So if you don't say something along the lines of the engaged couple or the bride or the groom or whoever it is shall, the engaged couple shall feed the wedding planner and his or her staff a guest meal, a wedding guest meal, then you might get something like some chips and, some dip and some celery and some carrots. That's not sufficient when you are on your feet all day. You all need to have nourishment. So make sure that your feed me clause or your dining clause is very clear. Also make sure, your travel is taken care of as well. Some people think a destination wedding is out of the state. A destination wedding to you could be 30 to 45 minutes or an hour away from your home base, because you all, if you do think about it, if you're at a rehearsal dinner, the day before the wedding really starts a lot. You're at the rehearsal dinner. Perhaps you and your staff have to drive an hour or so away, help them prep. And then that might be dangerous for you because the bride and groom, they're going to leave. You have to make sure that things are set up the day before the wedding. You guys could be working into the wee hours of the night. And then you might finish at 2 a.m. I don't know. God bless your souls. And then you get in a car and you drive back home at 2 a.m. Now you need to have a hotel.
Yeah.
To me, that's a destination. To me, that's just, keeping your safety. And so I think that should be in your contracts as well, so that you can get adequate rest and you can be close to the site of the wedding, and so that you're not putting yourself in danger. And the last clause, I know it's way more than 5, but write it all down. This is good stuff. A safety clause. You could go to a wedding and some of the guests are unruly, some other things that could happen outside of your control. I don't believe that you should subject yourself and be open to any type of abuse. I feel that you should ensure that the engaged couple understands that they are responsible for the behavior of their guests. If a guest began to sexually harass you, assault you, intimidate you, you can put either, listen, I'm allowed to leave if I feel my life or my safety is in danger, or that of my staff, or perhaps you will go as a courtesy, a one-time courtesy, to speak with the bride and groom, ask them to get their guests underway, and warn them, if this behavior continues, we're leaving because we need to feel safe. A lot of people don't have those safety clauses in there, and then they get into a situation where, someone's unruly, people are hostile, you never know the temperament of certain people, and you feel like, I can't even leave because I might breach my contract. So you almost feel like you're stuck and you have to stay. So those are a few extras. Another extra is the contract lacks a model release. This is not just for photographers. A model release is you requesting permission to use your client's image and likeness for advertising, trade, promotion, and any and all future media. Let's be real. People are going to be on your Instagram pages, your Facebook pages, your websites. They want to see your work. They want to see the beautiful weddings that you do. Some people just like to look at them because they're just so beautiful and they're not even engaged. Or they have friends that are engaged. I found my wedding planner through my maid of honor because she knew. So you want to make sure to the best of your ability that you have the ability to showcase your work and showcase the weddings, because that's how people are going to know the quality of your work and whether or not they want to work with you.
Yeah.
And it doesn't need to be a separate agreement. It can literally be a paragraph within that main agreement. And one of the last things we'll talk about is a non-refundable deposit. Some people call this retainer. I don't really like calling it that. I like to call it a non-refundable deposit. And this can be treated as a liquidated damages clause. I know it's a little legalese, but roll with me. Liquidated damages means it's a certain figure, a monetary amount that you and the engaged couple agree to in advance, that you would be paid if you are injured, or not physically injured, meaning that you are hurt, you suffer a loss as a result of someone breaching the contract. For example, someone could come, hire you to be their planner. They pay you $1,000 down of your $3,000 fee, your bridal package. And then you begin to work on the wedding, you secure a date, you secure some vendors, and then they come back to you, because some people can plan a whole wedding and get everything done in 2 weeks. Some people are just good like that. They come back to you 2 or 3 weeks later and say, listen, we found another planner. We don't really want to go with you. We think we're going to go with this person. Can we have a refund of all of our money? No, you're breaching the contract. We're not going to give you a refund of that money because you've agreed in advance that the non-refundable deposit can be retained. And in the event that the contract is breached or broken, the non-refundable deposit will be deemed or viewed as liquidated damages, because that's money that is meant to compensate you that you've already agreed to in advance because you've been injured. Because in a wedding world, 3 weeks is a lifetime in terms of booking another client and booking a certain wedding date. I'm sure some of you guys are booked out for 8/8/18. Can you imagine if a bride comes to you for August 8th, 18, and you're like, okay, no, that date's already booked up, and maybe 4 or 5 brides come to you after that, and your 8/8/18 bride then comes back later and says, oh, I want to cancel the contract. Well, you've allowed me to miss out a loss of profit on all these potential brides who are more serious than you. So that's why the non-refundable deposit is very important. Some people call it a non-refundable retainer. I don't like that term, but whatever is most important is you make sure your contract explains the meaning of whatever your non-refundable deposit or retainer is. It can't look like you're penalizing them for canceling outright. It needs to be drafted with very specific language so that it holds up in court. One flat fee of work usually does not work. A sliding scale is more likely to hold up in court. And this is an example of a sliding scale that I sometimes put in contracts. And
so we have a question about the deposit.
Sure.
So someone's asking, should there be multiple non-refundable deposits throughout the contract based on the clause? So based on a particular clause, should you have one for each?
Right. This is what I hear myself. Okay, good. I think that's a great segue into this slide, and I think that this will answer your question. So I wouldn't say there are multiple non-refundable, I wouldn't call them non-refundable deposits, but I guess technically they are that. If you look at the terms of the agreement, if you guys want to take a screenshot of this and pop it into your contracts, feel free, have at it. What I do for clients is there's a fee. The first fee is that non-refundable reservation fee or non-refundable deposit is due upon signing. You put the date in and the amount due. And then there's terms that are attached to that. It says the client shall pay this non-refundable, non-transferable reservation to reserve the time and date of services specified in this agreement. The non-refundable reservation is due upon signing. And then we break down the next payments, and even the first payment for the agreement, we make that due upon signing as well. We just break the two out. And then you can see you have your second payment and your final payment. Within the payment timeline, you see that kind of when those payments are due, on or before 6 months prior to the event, on or before 30 days prior to the event. And you can change this language if the wedding is, within prior to that time frame. And then the terms that accompany this is, in the event the client fails to submit payment on the due date, the planner should have the right to immediately terminate the agreement with no further obligation, retain any monies already paid, and not attend the event. So I think that this goes and answers that question, hopefully perfectly, because I don't continue to call it a non-refundable deposit, because a deposit is typically money that is put down for the promise of future services or to secure services, and the rest legally are construed as just payments. So it's very similar, but not exactly the same. And again, what's most important in contracts is you would clearly explain your terms. I can tell you right now, if you have something like this in your agreement, and the bride cancels the wedding, and then they want to sue you to get their money back, and you go and you take your contract to the judge, and he says, wow, every single time you paid, you saw this sliding scale agreement, and you saw that this was non-refundable each time, and that you agreed that they could already retain the monies that were paid and not attend the event, and you understood that they were performing services to plan for the wedding, but you still want the money back. The judge is going to kind of look at them with a side eye. This is much stronger, and it serves the planner well in a much better manner than if I gave you a lump sum payment. Because if I just said, hey, I'm paying you in full, I'm paying you in full, and this is how it's going to go down, then what happens is the judge will say, okay, so she paid you in full at the beginning. She paid you your $3,000 fee, and you want to keep all of it. In a judge's mind, you have to remember they are not in wedding planner world. They're in like legal world. So they're not working with creative clients like we are, or I am. So in my opinion, I think something like this serves you better. And then even at the bottom, I have an overtime fee. So let's say, for instance, you have to stay over, you have to do something else. And you can also say, listen, we had to pay over. This is the due date, which would be 10 days post the event. You already have your hourly rate. And then you can say what the amount due is. And you can fill that in at a later date and time. Hopefully this makes sense. Does that answer your question, whoever asked that?
Yes, and they have another one. They said, would this be used after the total amount is agreed upon? Or should this be just a standard fee that you have for all the contracts?
You can use this after the total amount is agreed upon, because I know sometimes that can be difficult to figure out. Sorry, my son's crying. I was like, what's going on? He's really tired. I was like, is he okay? Sorry. So yeah, you can use this. Some people will put this into the contract outright because they know and they understand what the total amount is because it's agreed upon in advance. It might be a little bit more difficult if you are a type of planner who, you might have other services. And I think sometimes you can utilize that invoice to come in. And some people have separate contracts, and that might be better. Sometimes they'll have separate contracts for things. So they might have a contract for planning, which this could pop right in there. And you already know what your planning fee is, right? Or most of the time it should remain the same depending upon the package. So that could be agreed upon in advance. And then there could be a clause within the contract that says, if there are add-on services, then that will be billed at a later date due to the needs of that particular bride. So I think I would handle it that way, just so it's easier for you, so that the bride knows that, oh, I'm paying for two different services, right? Because you have a contract that's for services and a contract for goods, meaning like maybe vases, table scapes, linens, things like that. So I would really break the two up. And you can still mimic this in an invoice, but I think that this is better suited in the event services agreement. Does that make sense?
Yeah, it does.
Okay. So the essential contracts that I think are needed is you must have, an event services agreement. Basically, that's the wedding planning agreement that outlines the scope of services that you will be providing. You also need to have an independent contractor agreement. So if you hire staff for the day of or to help you, that governs that, what you expect of them. And for some people who work a little bit more closely to you, who may be full-time staff, I would even consider having a non-disclosure and a non-competition agreement. If someone is coming on and they, you want to make sure your proprietary secrets are kept confidential. And if there's a non-competition agreement, you may say, okay, well, if you're going to work here and you're going to learn what I'm doing, then for a reasonable period of time after you leave, you are not able to compete directly with me within this particular region. Now, non-competition
Would that apply to interns as well?
Somebody else asked me that question, and I think, typically an intern is coming to you because they do want. Most of the time I'm thinking of an intern as someone like in college, So they're coming to you and they want that particular type of, they want the experience.
Yeah.
So a non-competition agreement is really mainly for employees. I don't think that it would behoove or be best for an intern type agreement. I don't even know if it would hold up in court because it violates the spirit of like an internship.
Right. Because they're supposed to be learning and being mentored at the same time.
Right, exactly. And, you have to make sure that either if they're getting some sort of class credit or if they are doing like substantial work that otherwise you would have to hire someone else to do, that they should be paid. They can be paid minimum wage, but they should still be paid. I always pay my interns. It's minimum wage. I mean, I can barely afford it because I'm a solo, but I still do it just so I don't get in any trouble with Uncle Sam.
Right.
So what I want you all to do is say, okay, Attorney Davis has told me I need all these agreements. Give yourself a due date to have all of these by. Maybe 30 days, 45 days from now. Make sure you get these in place so that you're fully covered. No, I'm popping your hand. I do not recommend websites or companies that auto-generate contracts like Rocket Lawyer or LegalZoom. Again, I would highly recommend you go to one of the other attorney sites and grab one of those. Mine will be up next month. But those companies like LegalZoom and Rocket Lawyer, they have that legalese in those contracts, and it's just not good. I have to correct those all the time for clients. So let's recap. So it's real. What did you learn today? We learned some common rookie mistakes that seasoned planners make. The essential contract clauses and mainly the essential contracts I believe you should have in place. I even gave you some bony rookie mistakes. And so now we're going to have our Q&A with Legal Bay. Again, Legal Bay is me. So if anyone has any outstanding questions, what I'm going to do is stop this share. And I would love to see if we have anything in the chat. Hopefully I can.
So we do have a couple.
Okay.
We have one from Teresa, and she says, should you have a contract for services and a separate contract for design?
Well, design. So you mean like wedding planning services and design services?
Yeah, so in terms of the coordination versus the designing of the wedding.
I would. And yeah, that might be something extra for them to sign, but they will be okay. They'll get over it because it really helps cover you, right? Because you're offering two completely different services and there's two different sets of expectations. So I would definitely have two different agreements unless there's a comprehensive like contract template that is able to blend both of them well. And I think I did one for a client. I drafted one for a client that was a wedding and event planning and design agreement. And so sometimes they can be brought together, but it has to be done very well.
Right. Now, Carissa also has another question. She says she does have her interns sign contracts only because they see confidential information about her clients.
Right. That's great. I mean, I would definitely do that anyway. I would have interns sign like a confidentiality or non-disclosure agreement, certainly, and something that even covers that internship agreement, and maybe throw in a clause that, this internship as a result, it's no guarantee of employment, and I would definitely say something like that. I think that's excellent that you have those in place.
We have another question. Do you recommend having a personal attorney for your business?
I think that it is, in my opinion, you may not need to have an attorney that you meet with every single month, but I think that there's a huge benefit to having an attorney who's able to grow with your business and understand the nuances of it, and having that relationship that you can build with someone who knows possibly what you need. You can literally set up, like for me, my hourly rate is $275. Some people are like, whoa, that's rich. Other people are like, that's not too bad. But if you set up a meeting with someone like me on a quarterly basis, every 3 months to check in, me saying, listen, how's your contract? Or maybe I can review the contract or something like that. In the end, I could reasonably anticipate if you might have an issue or assess the risk in your business, because we're meeting on a more regular basis. It doesn't have to be every month. And sometimes having that consultation and even attending, things like this, it can really help give you a lot of clarity on certain areas in your business, because I feel that when you know that the legal aspects of your business are taken care of, you're free to be a lot more creative in your marketing. You're free to be more creative in how you represent people. So because you don't have that thing in the back of your head like, oh my God, am I doing something wrong? And is someone going to come get me? That's never a good feeling. Trust me, that's why I have to go and talk to my accountant. I'm like, listen, what's going on? Reconcile my books. I'm scared of the IRS. And I see the benefit of having someone who's an experienced professional who understands my business.
Right. So Tanya says, what about a disparagement clause against fraudulent bad reviews and posts?
I've seen that, and you can incorporate that into the agreement as well. I think you have to think about that. How would a bride feel seeing that? Is that going to put them in a good position?
Yeah.
Are they going to feel comfortable signing something like that? And it may not stop them from, see, either way, it's illegal to defame someone's business. It's illegal to slander their business, right? So if they go and they make a review, and I actually answered this question from another one of my clients the other day. She posted it in a forum, and I said, you have to ask yourself this question. I like seeing a negative review as a potential customer, and I'll tell you why. I want to see how the business responds. Because I can tell you 9 times out of 10, the rest of the reasonable world can see when someone is being over the top and outlandish. Like when you read a review and you know someone is just being ridiculous, most of the time we never like it or comment. We just scoff and we're like, come on, lady. You expected the elephant to come and bring him into the bridal party? What? You know, some people have these crazy preconceived notions and expectations that are just unrealistic. And then I think that's an opportunity for you as a business owner to respond, not try to get the comment deleted, because nobody's perfect. Some people have these 5-star reviews, and knock on wood, because I do too, and I haven't had a negative review yet, but some people have 5-star reviews and you're like, come on, is it really that great? Like, come on, y'all didn't make no mistakes ever? Like, come on. So I think that it's an opportunity for you as a business owner to respond with grace and even say what you did do right. And sometimes it might be someone else, like the mother of the bride, say, well, the bride was extremely satisfied. We're sorry that you were not, but the bride was extremely satisfied with the services. And we even did this, and we tried to rectify the situation. Like my client was saying that they had to move the wedding from outside to inside because of the weather. She's not God. So now you're upset because you couldn't have this outside wedding. She cannot control the weather. And that's what the person was complaining about. It was foolish. So I think Patrice said, I am not into wedding planning. I only tailor to children's events. What's the best way to utilize the sliding scale when I have standard packages that are already priced? Well, I guess my question is, with those children's packages, are you requiring that they pay you in full up front? Because you might just need to modify the sliding scale so that there are less payments, and you don't have to break that out into over a 6-month period because it may not take you that long, all that type of stuff. So I think that you can definitely modify that sliding scale to still accept the deposit, maybe even accept the first payment, make sure that the terms are quite similar. And then if you accept subsequent payments, do the same thing. And I would even have the overdue fee, or excessive hour, whatever the heck I said, being held over, overwork. What is it? Let me look at my slides again. Overtime. Oh my goodness. Overtime fee, right? And you can even put that in your agreement as well. Let me see.
Now I have one question from the Facebook group. Someone said, does the client still have to pay me as a part of the cancellation, like if the event had to be canceled because of the weather? And I think this is someone that had an issue with the bride where because of the weather they had to cancel the event, and the bride didn't feel like she needed to pay the planner even though it happened on the day of.
Yes, they're still obligated to pay you because you've done all the work up to that point. Now, it's unfortunate that the event wasn't able to be held, but that's why you should have a force majeure or an act of God clause within your agreement, because that covers those situations where in the event you're not able to have the event come to the event because of an act of God. Perhaps you're trapped in the airport because there's a freak snowstorm and you can't make it to Maui, or Barbados or wherever. That's not your fault. It was impossible for you to perform. So literally, with this particular agreement or that situation, it was impossible for you to actually show up. Let me see. Let me see.
Latasha says, can you have a bridezilla clause? Funny but real.
It's funny. I don't know. I'm like, did y'all see my other client's contract that I ripped apart? She had a bridezilla clause in there, and I just looked at it and I was like, you can have that in there, but I'm telling you right now, as a bride, if I saw that mess, I would like, excuse me?
Yeah,
like
that would be a little offensive.
I would be offended. So you can call it something else, but don't call it a bridezilla clause. Like, you can have that, and you can say, in the event that the engaged couple abuses the staff, whether it be, certain things are like, that should be in your client responsibilities. In the event that you breach your client responsibilities, meaning talking to us, yelling at us, cussing at us, that is grounds for immediate termination of this agreement. Because you're abusing me. And I don't care how much money someone pays me. My clients, I'm not going to be abused by you. So I believe that should be in there. Don't call it a bridezilla clause. Maybe say acceptable client behavior or, client responsibilities or something like that. That's what I would call it that. So, yeah.
Okay, we have another one.
Okay.
If an act of God situation happens, can you put it that you'll attempt to get there?
Yeah, I think that you can say you will make any reasonable attempts to get to the particular event. Or you can also say that you will, within X amount of dates from the original date, agree to, host the event again if you can, or plan the event or something like that. So it's not that you're like, oh, well, that's it. So I think that might be helpful too if an act of God situation happens. Like, guys, 90%, in my opinion, of the work is done before the wedding date.
Yeah.
On the day of the wedding, all you're doing is executing everything. You've made the orders, you've ordered all of these things. These people still have to get paid. And just because the event didn't take place, it doesn't mean that it's not like you can miraculously get all that money back or that time. That would be the equivalent of me working or someone else working at a job. And then the job saying, oh, well, we didn't meet our quarterly projection, so you guys aren't getting paid. Wait a minute, sir. I did my part.
Yeah.
I don't know you guys, but I still need to get paid. So, I don't know why I can't see the chat. My chat's like disappearing. Okay. How do you write up the act of God clause in a way that doesn't scare your client? You can say it in a conversational way, I suppose, but you don't want to deviate too much from listing out events that would qualify as an act of God, or force majeure event, right? Because if you're too friendly, they might say, well, you said that the act of God clause was you not being able to do X, Y, and Z, not you not being able to hop on an airplane and get down here, So I think that you have to be careful with how much you limit the language, because you could put yourself into a bind. It's okay. Is it Ogie? You say you feel like you have so many questions. I do too. Every day I have questions, so it's completely fine. I'm always questioning life. So take advantage of the opportunity. I hope I'm rocking it. I'm the first person you guys get to chat with, so I hope you're having a ball with me.
Yes. First one in 2018. So I have another one from the Facebook group.
Okay.
They said, what should your liability clause say on the contract? That's a pretty vague one. I'm not sure.
She's talking about a limitation of liability. So
Okay.
I would limit the liability to the amount that they paid you for the contract or paid you for your services. Because otherwise, you don't want someone having in the law what we call as a windfall. My girl Judge Judy talks about this a little bit. The whole point, if a contract is breached or broken, is to make the injured party whole. Making someone whole means, okay, let me restore you to the place where you were before the contract.
Right.
Which means if you paid $5,000, I can restore $5,000 to you. That doesn't mean you paid me $5,000 and now you're a millionaire. No, ma'am, no, sir. That's not what this is about. And that's not the work of the Lord, okay? So what that means is the limitation of liability. I would say in the event, I don't have the language in front of me, but pretty much it would say something along the lines of, in the event the contract is breached or the event planner, wedding planner breaches the contract, and breach is a legal term. Don't say, well, I couldn't perform. Don't say in the event I canceled it. Don't say in the event I terminated it, because cancellation, terminating, you can't perform. That could literally be, I couldn't get on the airplane. And then you turn around and you have to pay them all the money back. That's not what I'm saying. Don't get fancy and get cute and say, well, okay, Attorney Davis said this, I'm going to use some different language. No, use breached, because breach legally means you did something wrong. In those other circumstances, you may not have done anything wrong. So what you'll say is, in the event wedding or event planner breaches the contract, the engaged couple's recovery shall be limited to the amount paid or the services paid. That's how you limit the liability. Otherwise, it could just get crazy.
So is that what takes out any emotional damages or any emotional compensation?
Emotional, that's a whole nother conversation. What I'm talking about is you not being able to perform your services, right? Yeah. And someone suing you for emotional distress is, I think, take me back to law school, but I think it's 3 to 4 elements that must be met for emotional damages. Like, you have to do something that is extremely negligent, and I'm gonna have to look it up now because that's just fun to do. Yeah. Emotional distress elements, always fun. Right? Intentional infliction of emotional distress. Okay. The defendant must act intentionally or recklessly. The defendant's conduct must be extreme and outrageous. And 3, the conduct must cause severe emotional distress. Severe emotional distress means you had to go and talk to Dr. Phil on the couch. Nothing wrong with that, because I've been to a therapist before myself. They are really good. They help you. But that means it has to be that extreme that it's caused them some sort of physical reaction within their body, like that they have to go and seek psychological help. Right. 9 times out of 10, that is not what's happening. Someone's just upset because it didn't go the way that they wanted to go. So right. Intentional inflict, and your conduct has to be extreme and outrageous. Short of you dancing on a table butt naked with a lampshade on your head, that is not extreme and outrageous. Sorry, I'm just a silly attorney, so hopefully that's okay. But it would have to be so extreme and so reckless that, and pretty much that would be a separate charge that I wouldn't even account for in this particular agreement. And most of the time, those things are thrown out by the court. So hopefully that answers the question.
Yeah, it does.
In a fun and colorful way. Okay.
So I see Carl says,
go Michelle. She says she's looking over her contract and she is solid.
Oh, that's good. Good for you, Michelle.
Transferable agreements. I would, Carl, if you saw within that sliding scale, I would say that the agreement is non-transferable. Like I said, the payment's non-transferable. It's not like, I paid you my deposit, but I don't want to work with you anymore. But my mom, they're doing their 10-year wedding anniversary. So can we transfer my deposit to their event? No. So put within your agreement that this is a non-transferable agreement, and that could be a separate clause as well. I think that's very important. Oh, you said we talked about wedding planning most, but can you talk about what we should look for when doing corporate or social events a little? I haven't really dealt with too many of those, but I think that some of the same principles apply, right? Because some corporate events can be much larger scale than weddings, and the
Right.
budgets are quite nice. If you all have not registered your business as either women-owned businesses, minority-owned businesses, or whatever, historically underutilized business, I think that that's excellent, and I would take advantage of those government contracts, especially in the off season for planning. So that could be additional income. So little nugget there. That's what I would do to try to get on those things. But I think in terms of handling corporate events, I think you really have to understand the nature of the client and their expectations. I would possibly consult and network with other people who are planning such events, and even ask them, maybe contact their whatever type of department. It could be marketing. What are they looking for? What do they want? I would do that R&R, that research, and determine how can, hey, listen, I'm starting this event planning company, or I've been doing event planning, but we want to expand to corporate events. What is it that you look for your corporate vendors? And, we're seeing what we can do to possibly, play in that particular ball game. And most of the time, people are more than willing to share with you the information. All you have to do is ask. So I would do those things. Make sure, if it's still payments, I would put a very similar sliding scale in there. And think of it, corporations, I would probably have my event a little bit more legalese, because they're used to that. They're used to that legal language. They're not afraid of whatever your pricing is. They're not afraid of those things. They are used to all of those things. So I would not alter the contract as much as I'm sharing with you all right now. Someone says, if you have a sliding scale payment schedule set up in the agreement with a non-refundable deposit, but when the client sends in the signed contract and payment, they send in the full amount, do you need to redo the contract? No. What I would do is I would send 2 separate receipts. I would say, thank you. This is your receipt for your non-refundable deposit. This is another receipt for your payment. And I would make note of it. And sometimes in these electronic agreements, when they make the payment, you can have them initial. Like I know sometimes in like Dubsado or DocuSign, I would have them initial next to the payment. That's another way to ensure that they are agreeing again to the terms of your payment plan and sliding scale. You can maybe add another column, which is smart. I'm going to do that for my clients moving forward, but have another column and then have them be able to initial it each time they make that payment. Let's see. Got to run to a meeting. Will this be available at somewhere for, that's for you, somewhere for review? I don't know. She's recording it. I don't know.
Yes, guys, I am recording it. And once it's edited, I will have it loaded in the group.
Lovely. What's the disconnect with the bride when you send the contract and they don't book with you? I think that, Paris, I think it could be not necessarily, it could be the contract. It could also be the onboarding process. A lot of brides are just trying to shop around. Some people are DIY brides. They just may not be assigned. I feel like there are certain people that are assigned to my business. That's just what I say. I say, gosh, this is my ideal client. They're assigned to my business. I'm supposed to serve them. And I always walk around when people wouldn't hire me as their attorney. I tell my cousin, my husband, who's a cousin? Okay, cousin, husband. That's weird. I don't have one of those. I would tell my husband, oh, they're not my ideal client. They're not my ideal client.
Yeah.
And that really helped validate that my standards were my standards and that I shouldn't deviate or lower them. Yeah. And that's okay, that this person is just simply not assigned to my business. So I think you can look at your overall process. One of the things that I started doing that has helped me retain more clients is have a script. So if you are talking with a bride, I would have a script. And my script literally is me sharing with them who I am and why I started my law firm, even sometimes sharing me being discriminated against because I was fired for having a baby and working these terrible jobs, and realizing, you know what, either my life is going to suck or I'm going to take my life into my own hands and start this business that I never wanted to start in the first place. My back was against the wall, and it's the best decision I've ever made in my life. I've had an incredible year, and I know it's going to be even better. And then just wanting to serve people at the highest level and give them access to fun and engaging not necessarily legal content, an attorney that they can relate to and not feel intimidated by and be like, oh my gosh, this lady's scary. She's got law books and stuff on the wall. And just like, attorneys make people feel really weird. Like,
Yes,
people get intimidated by them, right? And I was like, I looked up, before I started my business, I looked up every single bad thing people said about attorneys, all the lawyer jokes, everything. And then I said, I'm going to be the opposite of that. I'm going to have payment plans. I'm going to have reasonable fees. I'm going to be supportive. I'm going to be fun. I'm going to be engaging. I'm going to be, all these things, and creative and, appealing. And that really began to attract people who were drawn to me. And so I think, Paris, you have to figure out what's going on in my process. Is that serving me well? Am I really taking full control over the consultation with the bride, or are they running all over me? Do they even understand and see the value that I can give to them? If so, what can I do to communicate that so that really they see the passion, my heart, my drive? And if you figure that out and they still don't book you, then it's not on you. It's just, they're just not meant for you. So that was a little motivational speech.
That was good. Thanks for that.
That was extra. So let's see. Carl says, transferable regarding event planning. Individual engaged couple signs with the corporation. Planner assigned goes on maternity. C Corp reassigns to another planner. Oh, okay. Got you, Carl. I think that you should have a clause within that particular agreement that says something in the event the planner is not able to execute the agreement or perform, a reputable, what is the language I use? Something along the lines of a substitute planner of the same like experience,
right, and skill level, more or less.
Skill level experience will be substituted. So I think that something along those lines should be put in there in the event those things happen. Can you put a clause to just consult and not manage the event? Yeah, if someone, I wouldn't necessarily as a clause. I would just say that that's the nature of the agreement.
Right.
That the agreement is for you to consult them, not manage the event. So that would be the scope of services. You would have to make sure that is clearly defined within the scope of services. So it's certainly possible someone may be interested in that. Okay. You're welcome, Michelle. Tammy says, some Facebook groups, I know a lot of people tend to ask someone to share contracts. Is it safe to use someone else's contract as a start? Some people do that all the time. Sometimes it's okay. What happens that I don't like is people take 5 contracts and y'all put them together and you have a Frankenstein agreement. It's like, blah, 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 blah. It's so many different pieces of a contract. So we call them Frankenstein agreements. So I think, this is my opinion, it's much cheaper, in my opinion, to take an existing contract, perhaps you put it together, the other industry professionals have put together, and then bring it to an attorney, and then that attorney can review it. Sharing contracts, I would say if you buy a contract template from me and you share it with other people, then that's a violation of the license that I've given you, because I'm giving you a license from one contract. And if I figure that out, that's not going to be good for you. So, because it would be the equivalent of someone hiring you to perform a service and then duplicating your service and having you serve someone for free for subsequent events. And I think if we look at it like that, then you might be like, oh, I think I would not appreciate someone perhaps, or here's the thing. Have you all created timelines for brides? Some planners are very possessive over their timelines. Don't share my timeline. Don't share my timeline. How would you like it if someone shared your timeline all over the world with other people? Oh, I'll just send you the timeline my planner gave. You wouldn't like that because it's a violation of your intellectual property and your copyright. So us attorneys don't appreciate you all sharing contracts, but you can do whatever you want to do. But I think you have to think of it that particular way. It is a good thing to start. Try to get a contract template. I don't know if it's going, I can't say if it's going to protect you because I haven't seen the contract. The contract may suck. So, yeah. Oh, Latasha says, I love your personality, by the way. Your first warm attorney I met.
I absolutely love that.
Oh, I love you. So sweet. Okay, hold on. Let me Oh, Latasha says, how do you get over the intimidation of owning your own business, the responsibility of running a company, paying employees, etc.? It is a lot sometimes.
Yes.
Amen, sister. I don't know. I think, you know what? And I'm still there sometimes where I'm like, I'm responsible for all of these different spokes in the wheel.
Yeah.
And I have to remember that what is the alternative? You know, for me, I enjoy the freedom. Like today, moving forward, I will no longer take engagements and things on Thursdays because this is the day for me and my son. I have a 20-month-old son. I took him to music class this morning. Normally we'll go out for lunch and we eat and we have fun and we go to Discovery Place and we just laugh and we play. And that helps me remain grounded. I never would have that type of freedom working for someone else. And those things are important for me. And it helps really weigh and balance out the scales of all the responsibilities I have. And it makes me realize some of the things I stress out about are really not that deep and not that serious. So I think as you continue to go with time, make sure that you take those quiet moments with your family for self-care, whatever that may mean to you, and then say, okay, what is the alternative? Is the alternative of doing this or not doing this, is that worth it? And it gets easier along the way. Yes, you feel like you are everything in your business when you start before you can get some support. You are the lawyer, you are the accountant, you are the social media manager, you are the planner. You are everything, you know? But as time goes on and you begin to get really good systems in place, that is one of the top things I could tell you. If you have systems in place that serve your business, it makes life so much easier. Begin to document your processes. In my trademark process, I have 75 steps. I didn't realize I had 75 steps. I was like, I'm thorough. But when I documented the steps, I was like, you know what? I could cut 3 days off of this time for clients because I'm duplicating this work. Why am I having these two steps separate? They can come together. Then it allowed me to serve people at a higher level. So I think you have to begin to document things. Do you have like Acuity or Calendly on your website? So that instead of you trying to figure out how to self-schedule appointments, that a client can schedule an appointment with you themselves. Do you have email autoresponders that can be set up in Dubsado? You know, I have it where I have Dubsado. The legal software they have for us guys, it sucks. It's terrible. But I said, let me do what the creative people are doing because they got it on lock. You know, 17 Dubsado. I use Dubsado. Someone puts an inquiry on my website and then they turn around and just put my website right there. You put an inquiry on the bottom of my website, you get an email autoresponder to schedule that meeting. Then you're in my leads, you know, now you can get on my mailing list. So sometimes having those things in place, that really helps you. And I think it'll cut down the intimidation. Most of the time, you know more than you think you know. Yeah. Like most of the time, I'm like, you know what? I'm all right. I know what I'm doing. I got this. And sometimes you have to continue to tell yourself that I got it. I know what I'm doing. You're talented. And then you can continue to build. And I say, sometimes I'm like, God, I don't know what I'm doing right now, but you know what? Thank you, because that means I have room to grow. That means I have so much more to learn. That means that I can mature more. So sometimes I look at it that way, that it's not an offense to myself. It's not that I'm condemning myself. It's that I have so much more room to grow and really be greater than who I am right now today.
Perfect. My God. Thank you so much, Ticora. I think we're going to wrap it up. But before we do, we had a few questions about your services. I had a couple that were asking about your prices. If they know that your contract website is not opening until next month, but if they could still connect with you to purchase a contract. So if you want to just give everyone a bit more information about how they can follow up with you, get in touch, and more about your services, that would be great.
Of course. And you know what, guys, I would actually welcome that. I'm probably going to sell my contract templates at like $250 or $199, but I would probably sell them to you all for $97, only because I would love any feedback, and you all are the professionals. You can say, you know what, Attorney Davis, I don't like this, or I do like this. So if someone wants that or is interested in a wedding contract template for $97, just shoot me an email. Normally I'll have it up and running on the site, but if you're interested, shoot me an email. You can PayPal that money to me, and then I'll make sure you have it. And I'm open to constructive criticism, because I want to provide anything that is, I put it in the email, Ogie. If I'm open to constructive criticism, because I want to serve people at a higher level and with the utmost integrity. So if anyone's interested in that, you can connect with me at those places. I'm also on Facebook and Instagram at Creators Lawyer. I have a lot of fun and engaging videos and a lot of content. So I do contract drafting, but I'm trying to get away from that, and I'd rather get into the templates. I do mainly a lot of trademarks, so I help people protect their business names. I help them protect their smarts, as they say, and even copyright. And I also help individuals form businesses too, but the bulk of the work I do is trademark legal services. So I'm your regular, around-the-way creatives attorney. That's who I am.
Thank you so much, Ticora, and thank you so much, everyone, for joining us today. I will have this video edited and posted in the Facebook group, as well as circulated to the email list. And again, if you want to follow up with Ticora, she's available at the creatorslawfirm.com or Ticora at creatorslawlawyer.com. I posted in the chat. Ignore my misspelling and mistake. Thanks again for joining us, guys, and have a wonderful day.
You too. Thank you, Jody, for this opportunity again.
Thank you. Bye, everyone.
Bye.